Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, you know what the most common question is that I am fielding right now, and have been fielding this very common question for the last several weeks? It's this one. What the hell is taking Judge Benitez so long? And I honestly do not have an answer. And I've tried to geek out with a lot of other people who geek out on this topic, and we simply cannot come up with a reason as to what is taking them so long. Now, if you recall, we did this video way back in the day where we said, hey, there were 5 cases out of California, and we predicted that it was going to be a big sweep. The first 3 of them came out right away, but the 2 that we've been waiting for the most, Miller v. Bonta, Duncan v. Bonta, we're still waiting for. Perhaps we have an answer as to what may be taking Judge Benitez so long on the case of Miller v. Bonta as it relates to the assault weapon ban. So let's spend a few minutes today, get you all up to speed on a case you need to be aware of, which is the case that could crush assault weapon bans before Judge Benitez ever gets the rule. Okay, so the case we are talking about today is the case of Rupp v. Bonta. We have spent a lot of time talking about Miller v. Bonta. Rupp v. Bonta is also a challenge to California's assault weapon ban. It actually predates Miller v. Bonta. It was the first case that was filed. It got all stuck up in the system as we awaited for the Bruin opinion, and then got ricocheted on back down to the trial court. And so it has followed along a very similar path to some of these other cases that we've been covering, predominantly out of California, and it has been stuck in a state of legal purgatory for some time now. Now, for those of you who are not familiar with California's assault weapon ban, what California first did is they passed a penal code 30510, which created a laundry list of makes and models that were going to be banned by California's original version of an assault weapon ban. For my folks here in Washington, does that list sound familiar? Yeah, actually it was cut and pasted into our assault weapon ban directly out of California's. Now, after that went into effect, California was still unsatisfied because they had not quite achieved civilian disarmament yet. So they went and passed California Penal Code 30515 a couple of years later, which was the common characteristics ban, or basically if we have a centerfire semi-automatic rifle that accepts a detachable magazine and it has any one of the following components, it also is now a banned assault weapon. What Rupp challenges is both components of California's assault weapon ban. So the make and model, the big no-no list, as well as the banned component list. Okay, so this is a complete challenge. Now, when the case was first filed, it was argued in the Central District of California, and it was dismissed by the trial court, so therefore the state of California prevailed. Now, Rupp appealed to the Ninth Circuit. That case was actually heard before the Ninth Circuit in October of 2020. But then the case was put on hold while we awaited for the rulings last summer in the matter of New York Pistol and Rifle Association v. Bruin. When the holdings of Bruin came out, that case was then punted back to the Ninth Circuit, which immediately turned around and punted it all the way back down to the trial court, asking them to reconsider whether or not this matter should have been dismissed. Well, now this matter is set for a summary judgment motion on July 28th. And I'm going to explain to you in a moment what a summary judgment is. But this case is alive and well and has the potential, I'm not saying this is going to happen, but it has the potential to absolutely eviscerate assault weapon bans. Let me explain how. A summary judgment is a motion that can be brought by either party, plaintiff or defendant, which basically says, hey, listen, there really is no dispute as to the facts. There really is no dispute as to the law. Therefore, we don't really need a trial to go on some fact-finding discovery mission here, because we all know what the operative facts are, and the judge should just make the ruling based on that. The party who files for summary judgment basically is saying to a judge, hey, we don't even need a trial. You should just rule in our favor right now. Now, both sides, plaintiff and defendant here, have filed for motions for summary judgment. I've had an opportunity to read the pleadings from the plaintiff's motion for summary judgment, and I got to tell you, these are some really, really good pleadings. But this is what I need you to understand. And again, the likelihood of this we can debate on and on and on. But if the trial court granted a summary judgment on behalf of the plaintiffs, that essentially strikes down California's assault weapon ban in its entirety. Now, once again, that case is set for July 28th. All briefings and pleadings and everything are due by July 14th. Now, again, as I mentioned, I've had an opportunity to read the plaintiff's motion for summary judgment, and I like where they're going with this. Let me explain to you now exactly, if we take a look at a summary judgment, okay, that is, there is no material dispute as to facts or law. Let's just apply the facts and the law to what we got here, and let's rule in our favor. You will see exactly how plaintiff's counsel very creatively articulates this argument. This court should grant plaintiff's motion for summary judgment because there is no genuine dispute as to any material fact, and the plaintiffs are entitled to judgment as a matter of law. Material facts are those which may affect the outcome, and a dispute is genuine if there is sufficient evidence for a reasonable jury to return a verdict for the non-moving party. The Supreme Court has confirmed that the only material fact relevant to the resolution of the assault weapon ban's constitutionality is whether the banned rifles are typically possessed for lawful purposes by the American people. So you can see here, it's not so much the Bruin case that's going to get hammered on here. No, it's actually District of Columbia v. Heller, which is exactly the right case law argument to be making here. Plaintiff's counsel also states all instruments that constitute bearable arms, even those that were not in existence at the time of the founding, come under the Second Amendment. If an arm is typically possessed by law-abiding citizens for lawful purposes today, then it may not be banned. That is the irreducible minimum of the fundamental right of the people to keep and bear arms. A state may not prohibit an entire class of arms that is overwhelmingly chosen by American society for a lawful purpose. And of course, one of the things that you're arguing to a court when you're arguing for summary judgment is, Judge, hey, this is easy, okay? Anybody can see this. It's obvious, okay? And how plaintiff's counsel here put it was, that makes this an easy case. The Supreme Court has made clear that when a court confronts a flat ban on the possession of a type of arm, the only question is whether the arm at issue is typically possessed by law-abiding citizens for lawful purposes. If the answer is yes, then the ban is unconstitutional because the state cannot prohibit ordinary law-abiding Americans from possessing what the Constitution explicitly entitles them to keep. And as explained below, the answer here is unequivocally yes. And so what we're getting back to, and we've geeked out on this a bunch of times on this channel, is the common use test. There is a historical analog that permits the banning of certain types of firearms in American history. They are firearms which have been deemed both dangerous and unusual. When we are talking about the most commonly sold, most commonly used modern sporting rifle for so many different lawful purposes, there is nothing unusual about that firearm. As plaintiff's counsel put it, in sum, Bruin and Heller confirm that whether an arm is dangerous and unusual is a historical question, not a textual one. The state thus bears the burden of fitting the assault weapon ban's restrictions into a historical paradigm. It cannot meet that burden because the Supreme Court has already decided that there is no tradition of prohibiting arms in common use like the banned rifles. And to take this very complicated equation and boil it down to its most simplest point so that the court and all of you could understand what this case is really about, plaintiff's counsel states, this case thus reduces to the following straightforward inquiry. Are the rifles that the AWCA bans in common use according to the lawful choices of contemporary Americans? Because they unquestionably are, the AWCA's ban on them is unconstitutional. So it is entirely possible that Judge Benitez, for whatever reason, is waiting to see what the court's going to do in the matter of Rupp v. Bonta. Now, again, the case is Rupp v. Bonta. It is set for arguments on the summary judgment motion on July 28th. We're going to reach out to plaintiff's counsel, see if we can talk to them about it. And obviously, if anything happens in the meantime or anything happens related to that case, you will be the first to know. In the meantime, if you got any questions about this issue or anything else related to what's left of your Second Amendment rights, you guys should know how to contact Washington Gun Law by now. But if you don't, that's okay. That information is down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.